All right. I'm gonna wait a minute to make sure. Wait a minute. Make sure I'm live. IAAH Radio for broadcasting me, Judge Desire for Knowledge, and on legal matters today, which is a monthly show. So basically, you don't get to hear this show as much. It's a lot of content and details, and I normally don't do it live. Can you hear me, moderator? Hello? Am I live yet? I don't want to keep my listeners waiting on IAAH Radio. The best DJs and the best music in town. So, welcome everyone, the listeners and viewers. Thanks for your participating in this show. On my shows every week, I come up with Know Your Truth Real Talk. Last week was fascinating, though. Did you check that one out? Not a lot of views on that one because I figured they're not going to get it if they're parents because most of the same people are doing the same things I stated in that video. So I'm not going to get a lot of views on the parenthood one, but it was pretty one of the best games people play. That was the best one. Moderator. Shh. All right. I'm live. I know I'm live on IAAH Radio. Go check them out. Best music, best DJ. Check out DJ 5 a.m. DJ Buggin' Hard, my husband, and his music was just wow on Thursday and Tuesdays. Tuesdays on IAAH Radio and Thursday on House of Genre. It was kicking, both of them. Either way, we're here for my show now, but I'm not selfish. So this week, and if you hear any noise, that's the squirrels. I have acorn trees, so the squirrels are trying to get them. And with my roof being metal, you hear it. Either way, I'm glad to have you all here joining me. Like, share, and subscribe, please, so that this can be given to those in need. This week, I decided on this week, not just this week, because this week is not Know Your Truth. This week is Legal Matters because I was supposed to do it at the end of the month. However, I had a trio sequence going on with games people play, and I didn't want to interrupt it. So it's a week late, but it's here. So this month's Legal Matters is on rules and ADA on remote ADA remote workers after unions pressure. What happens here is the fact that ADA is Americans with Disability Act, and they have been under pressure since COVID. And a lot of people, whether they were disability or not, were able to work from home. So those that were disabled, I'm just giving you a preview before I go in length. Those that were from home, thank you. Those that were from home, working from home, got adjusted to it, but those that are disabled preferred it. So basically, they tried to retain their status as remote workers. So it is now applied on the ADA, the American with Disabilities Act, that reasonable accommodations is now including remote workers. However, I'm going to go through the reasons, the steps, and what you need to do if you are disabled and you need to work from home, which a lot of people should, but not or many are able to do that because our employers usually want to have the upper hand, watch you all day long, don't treat us like adults and individuals. Some of us, and mostly government workers, because I've seen it where I work, and most government workers go through that. But hopefully, these steps will help you recognize what, and if you were ever to be disabled or you are disabled, what you need to do to actually um, move forward with your claims and your forms to file. All right. So, like I said, since the days of COVID, remote work has become essential. And now, even more, as we look at those who are disabled as a way for them to continue to work wages, some of them, and mostly of them, want to work home instead of going on disability, which is understandable. Some people want full wages and not a partial, depending on how long you've worked. Disability may not work for you, and you'd have to work full wage earnings. So, with that being said, the ADA, the American with Disabilities Act, and recent court cases have clarified how it applies to remote workers. An employer must consider remote work as a potential accommodation for a disabled employee only if it doesn't cause an undue hardship at work, um, and the employees can perform all the essential job functions from home, which is really important. So, if you know that you can actually work from home, you have all the because the materials are supposed to be given to you, the computers, but you have to have the internet. You have to utilize the technology behind that in order to stay home. They have to issue the computers and the software needed, and that's it. You have to have the rest of the technology in order to perform those duties if you request um, to work from home as a disabled person now. Most people are back to work. Some of us, we can work from home 1 day a week, 2 days a week. It depends, rotation, but we have to go in. But those that are disabled are most likely if you're working 5 day work week, you're working 4 days out of the week and going in once. And some of them can go in, they're home 5 days a week and only have to go in monthly. So, a federal court decision in August of 2025 highlighted that an employee's successful performance while working remotely during the COVID 19 pandemic is strong evidence that remote work is reasonable accommodation. So that's how it became a part of the act, the ADA Act. This makes it makes it more difficult for the employer though to later claim that in-person work is an essential function, which a lot of our government employers have, and I'm saying it because I work for the government, has done is saying that the work we do is more essential in office. So when I say in person, that means in office. Most government workers are doing that now. Government employers are trying to go around the ADA Act, American with Disabilities Act, to see how they can prevent from having you work home even if you're disabled. So what happens here is this makes it more difficult for the employer to later claim that in-person work is an essential function because of these ADA new rulings and about remote work, which cause hardship. They're utilizing undue hardship. Let me tell you what that is. Undue hardship for the employer is someone that says, we don't have enough workers, but yet they do. Some don't. If you work in the government, you have thousands of workers, in every unit, at least 100, maybe less. But if you're a small business, I understand. But this is how you can actually capitalize on filing those forms to if you're in need of reasonable accommodations. They can actually make you go in work. But these new laws, ADA guidelines, are now there for those who are disabled with disabilities who want to work remotely. So basically, you're going to have an employer that's going to want to say, well, I don't want you doing 2 days a week home. I want you doing 1 day a week home. Comply. But you can still fight it. For me, I would call in the union and talk to them before you file out your forms for the accommodations, reasonable accommodations, and then have them sit in there with you during your meeting so that they can know everything that's going on there. Because sometimes you'll be denied, excuse me, and not even know that you have a right. The union will know this unless you've done your own research. The union will know and be able to guide you along the way. That's what we pay them for. So don't forget that. I think I have a video on union rights, those of us that have unions. So as I was saying, it's making it difficult for the employer now to use their excuses of in-person work is more essential than working from home. So this new federal law that I'm talking about, federal court decision, I meant, that was declared, has also stated that there's no blanket bans. So what that means is employers cannot force a blanket policy that prohibits all remote work if it conflicts with the ADA, such as RTO. RTO is what I normally see them do. They'll go give you a week and then they'll go RTO, return to work. And when you return to work, then they could stop that reasonable accommodation from occurring again and they got you back into work when it's better for you to work from home. So it can no longer be applied to disabled employees who need remote work as a reasonable accommodation. So they no longer can um, put on a blanket ban. I'm going to discuss what that means later on, but listen to everything I'm telling you, because once you get I go through the other court cases that has been initiated on how we can win the case and what will make you lose a case. I'm gonna try to be brief, not overwhelming. I'm gonna make it legalese, comfortable, layperson comfortable for you, that you're not gonna have to um, decide whether you can understand the legal part. So another thing was called, this is very important, in individualized assessment, interactive. Okay, that process is an interactive process of good faith discussion between an employer and an employee, excuse me, to explore accommodations. This way, you can talk like, that's what you should be doing with your employer about which way you can go, because some of them do not want you doing remote work. They'll shorten your week. They'll do whatever it takes, but your money is your money. They make you part time. You're not bringing home the full time, right? So you don't want that. But you should still discuss in good faith between you and your employer to explore other accommodations. Employees must evaluate each remote work request on a case by case basis, considering the employer's specific needs and the job essential functions. So, what we're trying to do is eliminate those job essential functions that employers are implying that we have to do because of it being done in the office. And if you have a job like a court officer, since I work in the courts, I'm gonna name those titles, or captain, or you can't work from home. Those things are essential in-person functions. If you're clerical, a clerk, sometimes clerk can, in COVID they do, or clerical, you can work from home, obviously, and if you're disabled, you can assist in helping those clerks and clericals from your home. So those things are not things that are essential in need of being in the office, I should say, just make it simple. Essential job functions. Um, I wanted to talk about this one because we're talking about essential job functions. An employer is not required to eliminate an essential job function to accommodate an employee. However, the employer bears the burden of proving that physical presence is an essential function. So if you're saying to them, I can't do that here, they'll have to come and say, well, what I need you here, and prove how it's going to be better for you to work here physically than from the office, from home. And for example, something that is required in the office and not out, okay? That is no means can be done outside. Something that has no means can't be done outside of the office, okay? These are the things that we're talking about, because these are the things that employers comes after you for. Also, with that, recent court cases that employees own job descriptions. Have you ever gotten, when you got hired, a job description? We all do in the government. Or you have that before you take the position. They'll give you your job description, prior remote work approvals, and essential evidence of success. Remote performances can be used to prove otherwise. So, what I'm trying to say here is you can actually use your job descriptions to prove your case. Prior remote work approvals can prove your case, or those that have been able to do so, because they cannot allow a specific number to do the work and you can't, especially if you're disabled. Like, for instance, if there's people that aren't disabled that are working from home and they deny you, then you can come in now and say, well, my job description says this. We've done prior work and you've given me prior work, remote work approvals before this. And evidence of successful remote performance is also, so like when you get an evaluation and your evaluation was great, that can be used to keep you to be continued in working remote from home as well. Alternatives to full remote work. Okay, in cases where full remote work is not reasonable accommodations, employers must explore other effective options for the disabled. All right, this includes flexible work schedules. Like I stated before, they may try to give you that. Adjusted hours, ergonomical equipment, things that will help you be at ease to, mobily be able to use things to function, because some people have bodily disabilities and someone has vision impairments. Those vision impairments would be accommodating you with glare screens for those who are consistently on the computer, and et cetera, et cetera, et cetera. Those that are on the computer most of the day, that can really ruin your eyes. So these are like reasonable accommodations in person. All right, and the employer can fight that case. But like I said, if they have already have given you opportunities, even with COVID, and people that are not disabled are getting it, and you did before COVID and afterwards you weren't able to, now you can claim that. But like I said, my suggestion is to go to your union. They'll know the answer for your case and what you need to do, because the specifics here is public employees and private employees are two different things. So a private employee might be able to get what a government employee might not, or vice versa. So you have to check with your union. If you have unions, thank God, because make them work for their money, because some of them are lazy. I've seen them where I work. I had to put them to their place to do their job sometimes. Um, to fulfill their jobs. They need to do it. But like I said, what works for one company may not work for another if you're working for private. What works for private employees and public employees may not work in that industry either. So, what to know if you are an employee? Okay, so the first thing you need to know, and I'm sorry because everyone here keeps their land beautiful and they're always mowing. And then we got Mother Nature, which is beautiful. um, what to know if you are an employee. So, what you need to know if you're an employee is communicate everything in writing and document it when requesting remote work as accommodation. Clearly state on the form that your request is under the ADA guidelines and is related to your disability. Another thing to do is explaining the connections in that form is really important. Document how your medical condition affects your ability to work on site, um, and how remote work can resolve the issue. Participate in the interactive process. I just mentioned the individualized active process is very important, and I'll show you why in another court case that I have here that prove that someone didn't do these steps I'm initiating to do, as not advice, but as a suggestion. This part here is really important. Interactive process means to go to your employer and make sure that you discuss everything with that employer that you need, and have your union rep with you. Your shop steward, union rep, business agent, they call it in private arenas, and in government, we have representatives and shop stewards. So go to them and have them sit down with you so that they can explain what the employer is trying to tell you, and see if the employer is doing what he or she are supposed to do. But interactive processing is really important. Be prepared to explain the issue of your to your employer, and be willing to explore other potential accommodations, because they may not think that your physical disability or non-physical disability, because some people have disabilities you can't see, they may think it's not needed. So this is where you bring the union in to make sure, because sometimes it goes from that step to grievances to EEOC, which is the Equal Opportunity Commissions, Equal Employees Opportunity Commissions, which is another step. Some people it's PERB, but in this case, I believe it's the EEOC. I should have done that research, but I'm normally right about that part. Um, Before we even get to the stuff, these are the basic steps that you need to take if you're interested in doing remote work from home. And you need to file these forms instead of FMLA, and the other disability forms, which we are all given reasonable accommodations, so you can still get your full paycheck. You can still be on your job, but at home instead of in person. Or if you have to do in person, you're still getting not easy work, but something to adjust to your disability, which is the right. To have discrimination laws against people that come up against disabled people, just like race. and sex and all the other discriminations laws. This one applies as well. They cannot prevent you, but some people do not want to have to go on disability because you might not get your full wage. There's other things, and so reasonable work accommodation is put in place for those that still want to receive their checks, but they can't do the fulfillment of their job duties and don't want to lose their job to go on disability, which God knows I've said it in my Social Security disability and union disabilities, um, and civil service disabilities. All of these things take time and they make sure they have you wait, especially Social Security. From what I've seen, I've helped a few people out and it's years for some. So you're going without money. So I can understand why the ADA created reasonable accommodations so those that want to get a full earning and can still stay at their positions. This is important. So as I was saying, always connect. If you want to fill these forms out, which are called reasonable accommodations form, look up your contracts with the union, go to the union, they can show you the contracts that they made with the employer. If you have not read your contracts, you have not been at your meetings, let me tell you something. Whatever they sign off with the employer is really important for you to be know about it, see it, and know what you're voting for, because sometimes and anytime you may be subject to be the one that's needed, um, on something in that contract, and you fail to go and find out none of that is in the contract, so now you lose. I've seen this a lot of times. It's very important. Read the documents. Don't think that it's not important until it happens to you. Don't do it before it happens to you. We never know. Things do happen, medical, disability, all kinds of things. Check your insurances. What has the union come in agreement with your employer with? That's really important, people. I mean, laws is always going to be here because we always going to have it. So it's important that you get savvy on knowing the legal system and knowing, reading a book on legal. They have AI now, I hear, and if you don't know anything, I'd rather read. But they have, I think I mentioned this on one of my shows, and it's not for dummies. It's they have mechanic for dummies, but they also have law for dummies. I mean, we have Google. There's no reason for people not to find out. But if you want to specifically know about what's in your contract where you work, you need to pull that contract or that union and call them, whatever it is, before you get into a situation like this, because I've seen it happen to a lot of people. They didn't know. How didn't you know? I'm actually on top of all my stuff. And I'm really good at it because, and I'm not giving myself a pat on the back. It's just that I'm going to want to know what's in there because it's going to affect me one day in my life or people I know who works alongside of me. And if I can help another person or myself, I want to be ahead of myself to do so. Not behind the times going, oh, I didn't know. You kidding me? That's what they signed off. Yeah, get involved with your union. If you don't go to the meetings, at least pull up. They should have online services where you can go in the website, pull that up there, go get the manuals, the bylaws, and whatever it is you need. Because when you have to deal with reasonable accommodations before you try to go to disability, try to get reasonable accommodations because disability is going to be rough. I already put what Social Security permanent disability is. That's no joke. I put the steps. I've seen people go through it. Some win, some don't because they give up. You have to know what your contract is stating so that you can know the challenge, the channels you're going to take, okay, before it happens. It's good to be prepared ahead of time. But let's get back to this because I'm about to grill some real good food. Oh my God, I can talk about it, but I'll show it later. If not today, tomorrow, go check that out on my social media pages. I'm on all social media. I try to throw it up on YouTube as well once in a while. But either way, getting back to the subject, communicate everything in writing and remember to document it, explain the connections with your employer. I'm just reversing, going reviewing this, the connection of in your document to the medical condition you have is really important. You connect these dots and then you'll find out you win. But if you don't connect the dots, then you lose. Okay. So make sure that you interactively process with your employer and be prepared to explain the issue to your employer of what and how you need these reasonable accommodations. Because when you put in these requests, they can deny you if it's not done properly. And that's why you need to know most of your stuff. I hope the sunlight is not, I think the sun is about to go down. Um, Hopefully you guys see me. All right, let's move forward. What I was saying is most of these times they try to deny you and they're not supposed to. But if you're not going within the guidelines in the contract that your union made in agreement with your employer, they can. Then you're looking at yourself going on disability, either short term, long term, or permanent, which takes time. And in that time, if you're disabled, they don't expect you to work. So you're going to want to do reasonable accommodation. All right. So being with that, keeping communication with your employer, it looks good on you, whether that's your supervisor or whoever's in charge. Bring your union rep or shop steward so they can sit with you and you feel like an attorney without paying for them, because you do pay, but you're not having an attorney, which they're supposed to be your representative, like an attorney. Anyway, let's move forward with this because I want to go grill my food. All right, I'm going to show examples of where remote work accommodations were upheld by the courts, or at least it wasn't dismissed. Okay, the court declined summary judgment in the District Court of Columbia, I believe that's in Georgia, in August 2025 to an employer who was seeking summary judgment from an employee who actually took time. So genuine the genuine issues of fact is really important in the court of law. So when you go, you bring the facts, whether in-person work was an essential function and whether remote work posed an undue hardship. So here, the employer was supposed to prove, and they won. Didn't know they were declined because they couldn't prove that it was more important for that person to work in person versus remote. This is a disabled person we're talking about. So they're going to come up against you because they want to make sure that they have you where they want you. Okay. So this court declined a summary judgment to this employer. I don't have the name of the employer, but this is a really important case. Here's what the facts in this specific case showed. One, the employee previously worked 2 years from home with strong evaluations. That means your evaluations were approved. You was doing great. What's the reason now? Why can't I still work at home? Two, the employer's justifications claimed staffing shortages. That's what they said. The employer said they're going to do whatever it takes. Shortages, public facing issues, were challenged. They were challenged by evidence because they kept bringing up all kinds of things that were um, harmful to their work and production of producing. Or producing, I should say. So what happened here is it got challenged by the court and by evidence that remote work had not harmed operations. After all, they did challenge them, and that other employees were also allowed rotational remote schedules so they can still give you rotational um, schedules without saying, no, we can't, we need you in person. So this proof here that this employee did, she worked 2 years doing it. She or he had great evaluations, but now this employer wanted to take it away from her because she's disabled. Uh, I believe the 2 years was COVID, and now she wanted to permanently do it. So the court found the employer out of rejected their claims, and now it's still in court, I believe, still so as a lawsuit. So basically, I don't have proof of that, but it says it's still pending. But at this time, they proved the employer to be wrong. So this is a strong reminder that even if the employer asserts that in office is essential, if there's clear evidence that remote work has been done before, previously, or with other employees that are doing similar work, then an employee's denial can fail. So, like I said, if they deny you and you go to court and they find out that this employer denied you, then they get their court case is out the box. They're not no longer, not every court case though. I have another court case I'm going to try to go through as quickly as possible and show you how you could lose the case. This is how you win the case. You have proof that you've been doing it, even if you use COVID-19 before you decided that, wait a minute, I've been disabled all this time and I never used that to be able to work from home because it wasn't available to me till COVID. Okay, now it's available. All employers are doing it because they had no choice. Now that it's open to those in need like that. The ADA now states that all those disabled can claim for that. So if you are disabled in any form or manner, of course, your doctors are going to have to prove you to be disabled without you going on disability. So, with that being said, if that can be proven, you get your doctor's note, you file this form, you take the union in with you, you shouldn't be denied. Um, with those two aspects that I just said. Sorry for the air quotes. At least they're not throwing it over this way. Anyway, okay. So, with that being said, the employer is now I lost my train of thought. That happens. I'm human. Oh yeah, their denials can be failed. So those two things are important. If you've done work before, remote, you can utilize the work that we had to be remote. Most of us who have work that's not considered essential in-person work, like if you're not a police, cop, court officer, captain, sheriff, you don't need to be in person. Certain positions do and certain don't. So since that's not essential, every employer has to follow the ADA rules, right? So that's a strong one when you do use that, and that you can prove that there's no staffing shortage. Like this court case, the employer, I don't know if they misguided the court or lied. It doesn't say all of that. It just says that it was challenged and they were wrong. Everything was fine. They had no problems, no shortages, and operations went smoothly. So this girl's case was good. She remained on remote work until um, they work something out. If the employers, they always like to fight, so they'll hire lawyers to continue to prevent people from being full-time remote workers. Mm. How you doing out there? Are you all good? I know this is why I don't do legal legal matters live, because it's lengthy and detailed and it's a lot. But in any case, it's very important to do those things. This case is very strong because those things that were denied by an employer can be actually challenged later. So these are the examples we're coming to where remote reasonable accommodations were denied or limited. In Michigan, a federal court dismissed a remote accommodation claim because the employee abandoned what? The interactive process that I was speaking about with the employer, which you need to do, where the employee must explain how disability limits their performance and how remote work would help. Very important. So if you're not going to have this interactive process done with your employer, they can deny you. So these examples are where you can get a denial on your claim or limited abilities on the reasonable accommodations, which means our employer will probably try to stop you so that you can go on disability and leave for all they care. They just want to not comply most of the time with you not being, I don't want to say up under them, but they like this type of, I'm sorry, what? Great information. Thank you. They like to be in control. That's what they're here to do. They control things. So as long as they can control, see what you're doing, know what you're doing, they like that. Because if you're doing great and you have a great evaluation, why are you worried about me? My work is being fulfilled. I bring out enough work, enough production for you. So there's no reason for you to come now and want me to RTO, return to work, return to office, or return back to work, whichever one. So Michigan Federal Court, this one was denied because that person didn't explain how disability limited their performance, and the employee failed to sustain that discussion. Uh, because of that, the employee was therefore entitled to summary judgment. So summary judgment can mean a few things, but in this case, it means they won their case, and either that person could be fired or will have to return to work. Whatever happened there, happened there. I'm just giving you the suggestions that can happen because I work in the courts and I know the two things that would happen after a summary judgment is met. It doesn't mean all the time that it's money. It monetary, I should say. It means the person would have to return to work, period, or be fired, or be in person but not have the reasonable accommodations applied to them. So this clearly signifies that employees must stay engaged. We must stay engaged in the accommodation dialogue with our employers. This process is just as important as the request to accommodate. Okay. Bottom line on this is remote work can be reasonable accommodation under the ADA, but it depends on whether the employee can perform the essential functions of the job and whether it imposes an undue hardship on the employer. If remote work is granted, the employer must still provide necessary accommodations for the home workspace. Like I said, they have to give you their own computer. You're not allowed to do it on yours. Oh, sometimes they do. Because I remember when I was home doing my work, I had my own computer. I didn't want to take their computer because I have a good setup office myself, but they provided everything else, the software, the get in, blah, blah, blah. So with that being said, if you have most of the stuff, and I wanted to go work from home when it was COVID. So I made sure I told them, listen, I got this, I got that, I got that. What are you gonna give me? Because I don't need anything else so that I can work from home. And so with that, I was able to do so. And so now with these with disability, that's what's gonna happen. Employers must provide necessary accommodations for the home workspace. Um, this case that I was looking at in September 2025, where the union came up and actually put pressure on the employer, the CDC, is known now, but they were trying to prevent this remote work in the CDC. The controversy isn't was about the Center for Disease Control, prevention. What they did was they faced public and union pressure after announcing that they were no longer going to approve remote work as a reasonable accommodation for its disabled employees, which became a big case. And that's where the union pressure came in from people. The CDC later backtracked their statement because with the union calling the initial ban, that's the ban we were talking about, blanket ban, a violation of civil rights. So when they called it a violation of civil rights, it took a turn for pressure of the unions working on reasonable accommodations being there are still reasonable accommodations, but these CDC was trying to get rid, the employer themselves was trying to get rid of remote work totally, period, from their scheduling. They didn't want it as a part of their reasonable accommodations because you can't get rid of reasonable accommodations. It's the law. There's laws, discrimination laws, so you cannot, and these are in place for those with disabilities, so you cannot get rid of the ADA Act reasonable accommodations, but you can take one out. And they chose to take out work remote. So the CDC controversy of September 25 initiated the unions to bring pressure on the CDC. I remember a case being some pregnant woman got really sick after being returned to work. She wasn't disabled, but she was pregnant, and it caused her so much stress that they reconsidered because she almost lost a baby or something like that. Um, but they are trying to take away the reasonable accommodations for the disabled there. This incident reinforced that federal agencies like private employers cannot issue blanket bans on remote work for employees with disability. That's where we came in with the blanket bans. You know, they banned out specific areas of the ADA's reasonable accommodations because it's not just remote work. Remote work came after COVID-19 because these employees initiated it so they could stay in business, right? So that we could work and we can't call out or get paid because the courts get paid on snowstorms. Let me just say for the government, we get paid on snowstorms. So if it's snowing out there before COVID, we got paid without doing anything. They didn't want that anymore. So when COVID came, they're seeing that we were mandated to be out and they had to pay us without us using our time. And they initiated, this is only in reference to the courts, they initiated the remote work. So once it's initiated, you know that now that can become a reasonable accommodation. So how dare you put a ban blanket over it now, but it was good for you when it worked for you. But it's not good for you when it's for us. You see, I can't with employers. Okay, so with that being said, we know what we're dealing with when it comes to certain employers, and I can speak definitely for the government that that's how they work. And it's not something that's hidden. A lot of government workers know it. It's the norm, and you just have to know your stuff. Read your contracts, talk to your unions, do what you need to do there. I'll probably do another segment, not next month, but a part two on this because it's lengthy. And let's see what happens with the new rules going in place and how many more people are going to be able to file these claims for remote work based on reasonable accommodations. So thank you all for listening to this show today. This is my first live on legal matters because it's so lengthy and detailed that it's not as fun as my Know Your Truth Real Talk. So come check me out next week live on Know Your Truth Real Talk. I have a great topic. I think this one is for all men, or I'll do the all women, but I can't tell you what it is. Go check my social media page and I'll let you know what's going on. I'll say for women only or for men only. All right. I hope you enjoyed this detailed information here on legal reasonable accommodations with the ADA, and take your laws and your rights and take them. Make sure you make them work for you and not it work at you. So with this being said here on Legal Matters with me, Judge Desire for Knowledge, bringing you the truth and nothing but the truth, is now adjourned. And I'll see you next week. Wow, the sun is really bright out here today. All right. Thank you all for joining. Blessings to you all. Thank you. Thanks. Thank you all. I appreciate every one of you. Please like, share, and subscribe. And I will talk to you on the next one. Ciao. All right.